Hello, constitutional bodies. First one is a Election Commission of India. Stability. The Election Commission was established by the Constitution of India under Article 324. It is an autonomous constitutional authority responsible for the administrating election process in India at the both central and state level. Article 324 to Article 329 of the Indian Constitution. Composition. The Election Commission consists of the Chief Election Commissioner CEC and the two election commissioners since 1993, and the President of India is appointed the Chief Election Commissioner and the election commissioners. The function and power conducting elections, responsible for the election to the Lok Sabha, House of the People, and Rajya Sabha, Council of State, the State Legislative Assembly, as well as the officers of the Office of the President and Vice President of India. And it conduct both general election and the by-elections. The supervision of and control. Supervision, sorry. Supervise the preparation of electoral rolls and the registration of the votes and the ensure the free and fair election. Decide on the matters of the related to the both qualification of the candidate and eligible of the election. Allotted powers. The ensure the compliance with the model code of the conduct MCC during the election. Resolve the dispute related to the election process. Take the decision on the election related petition and complaints. The dealing with the delimitation. It oversees the delimitation of the constituencies based on the guidelines set by the delimitation commissions. The regulating political parties, the register the political parties and the allocate the election symbols and parties and candidates. The Election Commission resolved the dispute relating to the split merger and the consist of the political parties. Independence of the election commissions. The chief election commissioners can only be removed by the special majority in parliament or the misbehavior or the incapability, not at the pleasure of the president. Ensure independence. Service protection. The chief election commissioner's conditions can't be changed to his disadvantage after the appointment. Other election commissioners can only be removed based on the election commission's recommendations, issues. No qualification specified. The constitution does not define the qualification for election commissioners. Unclear tenure. The tenure of the election commission member is not mentioned. The post retirement appointment. The retired election commissioner member can still the appoint to the government position after affecting the independence. Important articles. Article 324 grants of the election commission authority and the responsibility for the conducting elections. Article 325 the provides for the uniform electoral rolls. The Article 326 the provides for the universal adult suffrage. Every citizen have the 80 years has the right to vote. The Article 329 ensure that the no election to the House of the Parliament or the state legislature shall be challenged in a court of law. Union Public Service Commission UPSC constitutional provision. They established under the Article 315 of the Indian Constitution. The composition, chairman and other member, the member of determined by the President. The appointment, the President of India appoints the chairman and members. The tenure 6 years until the age of the 65 years, whichever is earlier. Removal by the President on the grounds of the misbehavior after an inquiry by the Supreme Court. The grounds include the insolvency, paid employment outside duties, infirmity, and the mind, body, or misbehavior. The Constitution defines the misbehavior for the UPSC chairman or the members as being the involved in the being from the government contract the agreement except on regular shareholders in the company. Function and duties Article 320. The conduct the examination for the All India Service, General Central Service and Group A B services. The recruitment method, the exam, interview and promotion. The advisory role on the recruitment rules and the promotion. Disciplinary cases against the civil servant. The principles for the appointment and the promotion and the transfer, the pension claimed and other services related to matters, the presenting annual report and the president regarding its function, restriction on the advice. The UPSC advice is not binding on the government. The matter like the reservation policies and the services quota outside the purview. The compositions detail qualification. At least the half of the member must have held the government office for the least 10 years. No specific academic qualification prescribed. A member are the eligible for the appointment but they can't be engaged in the further employment with the government of India and state government after the recruitment. Independence. Security of the tenure from members. Condition of the service can't be altered to their the disadvantage after appointment. The expenses and charged on the Consolidated Fund of India ensure the financial authority. The chairman of the UPSC and C the hold the office is not eligible for the further employment in the government of the India or state. The UPSC member after leaving office can be appointed as a chairman of the UPSC or an SPSC but the ineligible for the other government position. The not eligible for the reappointment. The report and the accountability. The submit and the annual report to the president which is then stable tabled the parliament. Parliament may the discussed on the report but the can't be interfered with the decisions. The limitation can't directly enforce its the recommendation limited to the advisory function. The final decision rests with the government. They can't address policy issue or the reservation matters. State Public Service Commission SPSC. The constitutional basis the established under the Article 315 similar to the UPSC for each state. They act as an advisory body for the recruitment for a state service. Composition. A chairman and member appointed at the governor or the state. The member should have the experience in the public administration or the performance function. They conduct the examination after the state service. They advise advise the governor and appointment and promotion and transfer within the state service. Independence. The member are the protected by the security of tenure can't be the removed except the government. The based on the special procedure. The service condition can't be the altered to the advantage and members, the function and the powers. The recommends the appointment and the promotion and the disciplinary action within the state's civil services. Conduct the examination for the recruitment and the providing advice to the state government on the panel matter. Important article. Article 315 to 323 related to the composition power function of the SPSC. The Article 320 specifies that the it like advisory recruitment transfer and disciplinary action for the state service. The Finance Commission. The constitutional basis established under the Article 280 of the Indian Constitution. Its the primary role is to be recommended the distribution of the net processed taxes between the proceeds of the tax between the central and states. Composition. Chairman and the four member appointment by the government of India. Members should be have the expertise in the public affair, economic and administration. Function. The recommendation of the financial distribution determines how the revenue from the taxes should be the shared between the center and state. Grants in aid recommends grants for the state in the need, especially for those with the final deficit. A review of the fiscal status assesses the financial health of the state and provides the recommendation report. The submits a report to the president every 5 years, outlining its recommendation for the fiscal distribution. The independence. The member are the independent and they can't be the removed except by the president. The security of tenure for the chairman and the members. GST Council. The constitutional basis. The Article 279A the established the GST Council through the 101 Constitutional Amendment 2016. It is a task with the overseeing and the making the recommendation on the goods and the service tax GST issues. The composition. Union Finance Minister Chairman and the Union Minister of State for the Finance members. The State Finance Minister and members. Function. Recommended GST rates on the goods and services. Address issue related to the implementation of the GST. The recommended changes to GST laws and the administration. The advice on the compensation to the state for the revenue those do the GST implementation. Independence. Independence. While it is a comprises both union and state representatives, the council and operates as a constitutive and the decision making body without any hierarchical control. The working of the council. The meetings decisions are taken in the council meeting with a quorum of the half of the total member. Decision making and requires a three-fourth majority of the weighted vote of the members. The president and voting. The central government one third of the total votes. The state governments one third of the total votes. The validity and proceedings. The council proceedings remains the valid even if there are the vacancy infected in the constitution or the appointments or the procedural irregularities not affecting the case's merits. The National and Commission for the SC, ST and OBC. The National Commission for the Scheduled Caste NCSC, the constitutional basis, the established under the Article 338, the Constitution 89th Constitutional Amendment Act 2003, aim to safeguard promote the welfare of the scheduled caste. The function, the investigate and the monitor the implementation of the safeguards provided for the SCA under the Constitution. Inquiry into the specific complaints regarding the violation of the SC rights. The recommended measures for the welfare and advan- advancement of the SCs. The composition. The chairman and three members of the secretary. Power. The commission has the power to summon the witnesses, demand evidence, and the investigates the complaints about the SC and SC. Second, the National Commission for the Scheduled Tribes (NSCT), the constitutional basis, the create under the Article 338A through the Constitution 89th Amendment Act of 2003. The focuses on the welfare of the scheduled tribes function. Similar to the NCSC, it safeguard the right to promote the welfare of the STs. Look the complaints regarding the violation of the STs right, the recommended measures for the advancement of the ST rights, the composition, chairman and three members and the secretary. Power has the authority to then investigate complaints, call for evidence, and the monitor for the execution of the constitutional provision related to the STs. The National Commission for the Backward Classes, the constitutional basis, the established under the Article 338B through the Constitution, Article 102 and the Amendment Act 2018 focused on safeguarding the promotion and welfare of the backward classes SBs function. They investigate the condition of the backward classes and they ensure in inclusion in the central list of the OBCs. The inquiry into the complaints regarding the violation of the BC rights. The recommends the measures for the upliftment of the BC's right composition. Chairman, three member and secretary power. Can we investigate complaints, summon witnesses, and oversee the executive of policy for the backward classes? General feature of the this commission role in the monitoring welfare program. Each commission monitor the welfare program and assess their the effectiveness for the respective communities SC, ST, and OBC, BCs recommendation, and they make a recommendation to the government regarding the policies, law, and measures for the social economic upliftment of these communities. Report to the President. They report the annually to the President of India and the implementation of their recommendation and the other related issues. Controller and Auditor General of India. Constitutional provisions. Uh, Article 148 the establishes the Office of the Controller and Auditor General of India. The appointment and the CAG is appointed by the President of India. term. The term is the 6 year and until the age of 65, whichever is the earlier. The removal. CAG can only be removed by the president on the grounds of the uh, proven misbehavior or the incapacity, similar to the procedure of the removal of judges and the Supreme Court. The independence. CAG is the independent of the government report and the directly to the president and is not the subject to the direction of the executive and the discharging its a function. The independence of the CAG. The not eligible for the further office under the government of India or any state. The CAG can't be removed arbitrarily only through the procedures similar to the removal of a judge of the Supreme Court. His salary, leaves, rights, and the pension retirement age can't be alerted, and his disadvantages after the appointment. It operates autonomously from the executive and its a functional independence to the audit and the report on the government finances, duties, and the powers. Audit and accounts. The union and state governments. CAG audit all the government receipts and the expenditures, including the Consolidated Fund of India and public accounts. The government companies and the corporation. CAG audit the accounts of all the government owned companies and the statutory corporation. The accounts of the local bodies. CAG has the authority to the audit the local bodies, but such audits are done on the request. The report. CAG submits the annual report to the president who present them to the parliament or state legislatures. The key reports include report of the CAG on the union accounts, the report on the CAG on the state government accounts, the performance audit reports, the covering the specific government scheme or the program, the compliance or audit reports detailing the violation of the laws or the regulation. Power of CAG. Power to the conduct performance audit to the access of the efficiency and the effectiveness of the government program and the projects. Power to the recommend the improvement in the financial management and accountability. The CAG reports are the examined by the Public Account Committee PAC, which holds the government accountable for the audit findings. He is a guide, friends, and the philosopher to the Public Accounts Committee. CAG and the corporation. The CAG audits all the government companies, the public sector undertakings, the statutory bodies, the RBIs or SEL. The some corporation are audited by the private authority appointed in the consultation with the CAG, who may conduct the supplementary audit it's needed. The the corporations such as the LIC, RBI audit solely by the private authority, which is not CAG involvement, and the submit report directly to Parliament. Attorney General of India, the constitutional body basis the Article 76 of the Constitution provides for the office of the Attorney General function, the legal advisor, a chief legal advisor to the government of India. They represent the government in the Supreme Court and the High Court. The opinion and assistance gives the legal advice to the president and the legal matter can be appear in the cases on the behalf of the recommended to the case involving the public interest. The parliamentary role has the right to speak and and take the part of the proceedings of the both houses of parliament or their joint sitting, can be participate in the parliamentary committee of the which it is named a member but does not have to the right to vote. Independence and tenure. The AGI is the appointment by the President. No fixed tenure services and pleasure of the President. The CAG may resign by the removal by the President. Limitation on the Attorney General to the prevent the conflict of the duty. Can't advise the hold the brief against the government of India or its cases involvement it requires the government permission to the divide the criminal procedure or the accept the uh, direct directorship in the companies can only be advised the ministers department PSUs through the ministers of law and justice, advocate general of state. The constitutional bodies. The Article 165 the provides for the office of the Advocate General in each state. The appointment by the governor of the respective state function. The legal advisor to the state government. They act as the chief legal advisor to the state government. They represents the state in the high court and the other courts. The opinion and the advice. They provides the legal advice to the state government on the various issues. Can also appear to the cases where the state government is a party. The independence and tenure. The appointment as the AG is appointment by the governor and the hold the office the pleasure of the governor. Removal. Thus AG can be removed by the governor at any time. No fixed tenure. A special officer for the linguistic minorities. Constitutional body biases. The office of the special officer for the linguistic minorities is established under the Article 350B of the Indian Constitution. Function. The representation of the linguistic minorities. The officer is the responsible for the investigating the minorities matters related to the safeguarding of the interest of the linguistic minorities. The report to the president. The special officer submit and the annual report to the president on the working of the safeguard provided to the linguistic minorities in India. Recommendation. Make the recommendation to the president regarding the effective implementation of the safeguard for the linguistic minorities. Public engagement. They ensure that the interests of the linguistic minorities are partially represented in the governmental and the administrative process. The President of India appointments the special officer for the linguistic minorities. Non-constitutional bodies. NITI Aayog, National Institution for the Transforming India. Introduction. NITI Aayog was established on January 1st, 2015, replacing the Planning Commission. The function as the premier policy think tank of the Government of India, forecasting cooperatives and the federalism and the driving the strategy policy and program implementation. NITI Aayog has a specialized wings including the research wings and the expertise development and a consultancy wings. The connecting the government needs with the public private solution and the team India wings for the ongoing state and the ministry. The collaboration, the ensuring the condition development of effort. The National Institutes of Labor Economic Research and Development Monitoring and the Evolution Office and are the two offices stretched to NITI Aayog objectives fosters competitive federalism, promote innovation and develop long-term policy, encourage the sustainable development, monitor, evaluate. The key function, the policy formulation, coordination, think tank, monitoring and evaluation, com- competition, chairman and the Prime Minister of India. The vice chairman appointed by the Prime Minister act as the chief executive and enjoy the ranks of the cabinet minister member. The full-time member enjoy the rank of Minister of the State and the part-time members from the advisor sector. The Chief Minister of all state and Lieutenant Governor and Union Territory member of the Governing Council. The ex-officio members. The Union Minister of key departments. The special amnesty uh, innovatees expert specialized participation with the relevant domain knowledge. The key institutives, the aspirational district program focused on the developing underperforming the district in the health and education infrastructure. Atal Innovation Mission that promotes the innovation and the entrepreneurship in the schools and the colleges and the startups. The India Innovation Index that measures the innovation capacity of the state to the boost the competition and the improvement. The SDG localization tailor sustainable development goals SDGs the for effective implementation at the local level. The role in the policy formulation replaces the 5 years plan with the long term and short term action plan. Emphasize on the outcomes based on the planning and the non-grounds data. The promotes the bottom-up approach with the participation from the local government level. The differences from the Planning Commission aspect NITI Aayog and Planning Commission. Formation NITI Aayog 2015, Planning Commission 1950. The role NITI Aayog advisory and planning. Planning Commission centralized planning NITI Aayog bottom up based on the state's need. Planning Commission top down. Funds allocation NITI Aayog does not allocated funds. Planning Commission allocated funds to the state. The focused area NITI Aayog innovation monitoring and SDG and Planning Commission economic planning and the resources allocation. National Development Council NDC the establishment formed in the 1950. NDC is the non-constitutional body that plans a key role in the promoting the cooperative federalism in India. The purposes act as an apex advisory body for planning, reviewing, and the recommending the development policy and the strategy at the national level. The composition, chaired by the Prime Minister, include Union Minister, Chief Minister of all states, and Administrator of the Union Territories. Function. Reviews of the implementation of the 5 year plans recommends the strategy for the achieving the balanced socio-economic development, ensure coordination between the union and state in development matter, significant, serve as an forum for the discussion on the policy plan and resources allocation, the ensuring state wise and the presented in the national planning. The National Human Rights and Commission, the establishment set up in the 1993 under the Protection of the Human Rights Act NHRC, a statutory national constitutional body tasked with the protecting and promoting human rights in India. The purposes serve as the watchdogs for the human rights issue, addressing the grievances and the promoting the awareness and the education on the human right across the country. Composition: Chairman plus 5 members. Chairman: a retired Chief Justice India serve as the chairperson of the NHRC. Member: the two full-time member. One must be the retired judge of the Supreme Court. The other must be the retired Chief Justice of the High Court. The three-member person out of the which are should be a one. The ex officio members. The NHRC include the chairperson of the National Commission for Minorities, the National Commission for SCs, and the National Commission of the STs, of the National Commission for the Women, and National Commission for BCs, and the National Commission for the Protection of the Child Right of the Chief Commissioner for the Person with the Disability. Appointment: the chairperson and the member of the NHRC and appointment by the President of India based on the recommendation of the ex-member committees consisting of the Prime Minister's chairperson, the Speaker of the Lok Sabha, the Deputy Chairman of the Rajya Sabha. The leaders of the opposition in the both Lok Sabha and Rajya Sabha, the Union and Home Minister, the term and removal of the members of the National Human Rights Commission (HNRC). Term: the chairperson and the member of the NHRC serve as a term 3 years or until they reach the age of 70 years, whichever is earlier. The term was the 5 years before the 2019 amendment. Removal: the chairperson and the member of the NHRC can be removed from the office by the President of India under the certain condition. The grounds for the removal includes the proved that the misbehavior or incapacity or the determined by the inquiry led by a judge of the Supreme Court as the appointment by the President. The insolvency: if a member is the adjourned as the insolvent, the engagement in the paid employment outside the official duties, the mental or the physical incapacity, uh, rendering terms unlifted, discharge their the responsibility, conviction for the offense of insolvency, moral tributaries and the function. They investigate the compliance of the human rights and violation of the recommended cooperative action. The review factors, including law and the administrative process that undermine human rights. The conduct that promotes the human rights and the research and the awareness program. The advice to the government and the international human rights and the treaties and the ensure the enlightenment of the policy power. Can someone individuals grant evidence and the request to the information for the investigation, recommendation procedure or the suitable action but can't be enforced these recommendation leaving the final decision of the government. Linguist limitation: its role in a advisory and the lack of the enforcement power. It can be only recommended action to the authorities to the who may or may not capably the State Human Rights Commission. Composition: chairman must be the retired Chief Justice or the judges of the High Court. The member includes one member who must have been a judge of a High Court or the district judge with 7 years and the experience and the member with the practical experience in human rights. Appointment: appointed by the governor of the respective state in a consultation with the chief minister, the Speaker of the Legislative Assembly, and the State Home Minister. If there is a Legislative Council of Chairperson as also consulted. Term: similar to the NHRC, members serve as a term of 3 years or until the age of the 70 years, whichever is earlier. The term was the 5 year before 2019 amendment. Removal: member can be removed by the President, not the Governor. The following of the same process as the NHRC member, including grounds such as the proven misbehavior, incapacity, insolvency. Paid employment outside duties, incapacity, conviction for the moral tribute, tributed the jurisdiction. A state human rights commission can be inquiry into the human rights violation only within the state. Cases involving central governmental and employees or the institution or the reviewed by the NHRC, the power and the function are similar to the NHRC but the restricted to the state level issues. It provides recommendation to the state government aids and promoting human rights awareness and review the state laws and the impacting human rights. The Central Information Commission, CIC, the establishment and role. The CIC was established under the Right to the Information Act 2015 to act as the apex body to resolve the dispute and ensure the compliance with the provision of the RTI Act. Its role of the review, the inquiry and complaints relating to the denial of information under the Act and recommended the penalties against the public authority who do not comply. The composition. The Central Information Commission consists of the Chief Information Commissioner and the maximum of 10 Information Commissioners. The total number of the commissioners, including chiefs, and determined by the central government based on the need of the workload. Term. Term of the office both House Chief Information Commissioner and the Information Commissioner has the presided by the central government or until they reach the age of the 65 years, whichever is earlier appointed. The Chief Information Commissioner and the Information Commissioners are appointed by the President of India. The selection committee and the appointment include the Prime Ministers and the leader of the opposition in the Lok Sabha under the Union Cabinet Minister nominated by the Prime Minister. Removal. The Chief Information Commissioner or the Information Commissioner can be removed before the compliance of their term only in the President of India. The removal can be happen on grounds of the misbehavior and incapacity and the Supreme Court the inquiry in the necessary before the removal power and the function. The CIS has been powered and someone to enforce the attendance and the person examine the witnesses and the call for the documents. It can impose the penalty on the public authorities for the non-compliance with the RTI Act. The Commission has been the authority to the recommended disciplinary action against the official who obstruct the disclosure of information. The transparency and accountability. The CIS ensures the transparency in the government functioning by the enabling the citizen to the seek information. The serve as a member the mechanism for the accountability by the ensuring the public authorities and adhere to the RTI Act and the respond to the citizen inquiries. State Information Commission. Composition. The State Information Commission consists of the Chief Information Commissioner and the Information Commissioner at state level. The total number of the commissioner and the determined by the state government but not can't exceed 10. The appointment. The Chief Information Commissioner, Information Commissioner and appointment by the Governor of a state. The selection committee at the state level includes the chief minister, leader of the opposition, and the cabinet minister nominated by the chief minister. Term. The term of the office of the chief information commissioner and the information commissioner is the 5 years and until they reach the age of the 65 years, whichever is earlier, similar to the CIS. The removal. The procedure for the removal is similar to the CIC, but the governor can remove and the chief information commissioner or the information commissioner after the Supreme Court inquiry. The 2019 amendment to the RTI Act, the Chief Information Commissioner and the Information Commissioners. The amendment refused by the term of the office for the Chief Information Commissioner and the Information Commissioner for 5 to 3 years. The appointment and removal. The amendment empowered the government to decide the salary allowances and the tenure of the Chief Information Commissioner and the Information Commissioners. The Central Vigilance Commission, the establishment. The CVC was established in 1965 to address the corruption in the public sector and promote the transparency and accountability in the government service. Composition. The composition consists of the Chief Vigilance Commissioners and the two Vigilance Commissioners. The member are the appointment by the President and India based on the recommendation of the selection committees. The power and function. The CVC supervise and the candidates the vigilance activities in the various government agency. It can be investigate compliance and conduct inquiry and the removed disciplinary action against the public servants and the involved in the corruption. The CBC the oversees the functioning and the CBI in the matter related to the corruption. The appointment. The selection committee for the appointment of the include the Prime Minister and the leader of the opposition in the Lok Sabha and the Home Minister's term. The Chief Vigilance Commissioner and the Vigilance Commissioners have the term of the 4 years or until they reach the age of the 65 year, whichever is earlier. The jurisdiction. All Indian service member and Group A service of the central government. The scale V and 5 and have the office of the public sector bank. The Group D and above the officer RBI, NABARD and the SIDBI. The chief executive officer of the E8 and the above in the Schedule A and B public sector undertakings. The chief executive officer of the E7 above the Schedule C D public sector undertakings. The manager and above the general insurance companies. The senior divisional manager and the above life insurance corporation officer drawing the 8700 and above the pre-revised in the societies and the local authority controlled by the central government. Central Bureau Investigation (CBI) establishment. The CBI was established in 1963 under Delhi Special Police Establishment Act 2. The investigate corruption and the other criminal offence within the jurisdiction of the central government. The composition. The CBI is headed by the director who is appointed by the Prime Minister based on the recommendation from the selection committee, which include the leaders of the opposition and the Chief Justice of India. Jurisdiction. The CBI has the jurisdiction over the crimes involving the central government and the employees public sector and the enterprise as the cases reformed to it by the central government or the Supreme Court. It also has the jurisdiction to the investigate cases to the corruption, fraud, and the economic offense and special crimes. Power. The CBI has the power to investigate, prosecute, and arrest the individual involved in the criminal activities. It works under the guidance of the Prime Minister of the Personnel and the Public Grievances and the Pensions, and is governed by the Central Vigilance Commission and the corruption related to the matters. The CBI initially required the prior approval from the central government to investigate corruption cases involving the senior central government officer, joint secretary, and above. However, the 2014 the Supreme Court has struck down the requirement section 6A of the DPSC Act, the declaring it's a continuous constitutional under the Article 14 as created under the protection for the higher ranking official implementing of effective investigation of the corruption cases. Appointment: the director is appointed for the term of the 2 year, and the can't be the removed without the approval of the High Court and committee consisting of the Prime Minister and leader of the opposition and the Chief Justice of India. CBI versus State Police. The overlap of the authority. The CBI and the State Police have the overlapping jurisdiction, particularly in the case involving the offense across the multiple state and within implementation of the national security. However, without state consent, the CBI can't be the investigate cases within the state jurisdiction. While the state policy operates independently within the air state, the Lokpal and the Lokayukta establishment. The Lokpal and Lokayukta Act 2013 was the enacted the establishment anti-corruption authorities, the Lokpal at the central level and Lokayukta at the state level, aimed at investigating the allegation of the corruption against the public official and the ensuring accountability. The concept of the Lokpal and Lokayukt is inspired by the ombudsman system, the originally established in Scandinavian countries in the address the public grievances and overseas. Administrative action. The composition of the Lokpal. The Lokpal is the multiple member body headed by the chairperson, usually a retired Chief Justice of Supreme Court judges, and the up to the 8 members, half of whom just must be the judicial member within with the adequate representation of SC, ST, OBC minorities and the women. Jurisdiction. The Lokpal can investigate corruption allegation against the Prime Minister with the implementation court and the from the Union Minister member of the Parliament and the group ABCD government officer. It also has jurisdiction over the public servants in the government, the bodies, the public sector, undertaking the investigation, receiving the the sustainable public funding. The power and the function. The Lokpal has the power and similar to the civil court for the conducting the preliminary preliminary inquiries, directing investigation, and the ordering the prosecution if needed. It can be touch the property of the accused, summoned official, and the recommended the removal of the corruption and the official based on the findings. The Lokayukt state are required to the establish Lokayukt to the address the corruption at the state level. However, there the structure of the power vary from the state to state based on the individual state legislation. National Investigation Agency (NIA) establishment. The National Investigation Agency was established in 2008 following the Mumbai terror attacks. Under the NIA Act 2008, the handle the terror related cases, other offences affecting the national security jurisdiction. The NIA has the authority to investigate and the prosecute offences listed in the NIA Act. The schedule including terrorism, human trafficking, cyber crimes, and offences under the specific act like the Unlawful Activities Prevention Act (UPA) and Anti-Hijacking Act. Unlike other agencies, NIA undertake up the cases without without the consent of the state government if the case involves the national security, giving the jurisdiction across India. Power: the NIA can the function as a both investigate and the prosecuting agency. It can arrest and the search the seize the property and during the investigation. It operates the special NIA court and the shift the trial case under the jurisdiction. Recent amendment: the amendment in the 2019 extended the NIA's power to include cases of the human trafficking and drugs trafficking and cyber terrorism, enabling the address of the broader range of the offense related to the internal security. Enfor- Enforcement Director (ED) establishment: the Enforcement Director was established in the 1956 as an agency under the Ministry of Finance and Enforcement economic laws and the fight financial crimes. The mandate and the function: the money laundering and investigate offense under the prevention of the money laundering and the MPL and the targeting the illegal money of flow follows the ensuring the confident uh, confiscation of the tried asset. The foreign exchange violation: they enforces the Foreign Exchange Management Act (FEMA) to manage the violation of related to the foreign exchange regulation. The cross-border financial crimes work on the access involving the howler transaction, sell companies and other illicit financial activities and the affect the Indian economy. Asset seizures: can be seized the asset both within India and abroad. Cases in financial fraud or the money laundering. Jurisdiction: AD operates the nationwide with the power of investigate and the prosecute individual and the organization involved in the financial crime that have the national and the cross-border implication. The power: the ED has the authority to arrest, the attach the property, search premises and the freeze bank and account during investigation under the MPLA FEMA. It can collaborate with the other agency and the access international channel to the attract the representative laundered money. The National Disaster Management Authority: the National Disaster Management Authority was established through the Disaster Management Act 2005, enacted by the Government of India, and was formally constituted by the December 2006. It is the statutory body for the disaster management in the country. The mandate is the primary purposes to the coordinate the response to the annual and the made by the disaster and the for the capacity building and disaster recycling the crimes and the responses. It is also the apex body to the lay down the policy plans and the guidelines of the disaster management to ensure the timely and effective response to the disaster. The organizational structure: the Prime Minister is the ex-officer chairperson of the National Disaster Management Act Authority. Cabinet Minister: generally Home Minister, the Vice Chairman of the NDMA, and NDMA has the 8 member ministers. State its a member. The National Consumer Dispute Redressal Commission. The Consumer Protection Act 2019 provides for the establishment of a three-tier consumer dispute redressal mechanism to district and state at national level. District Consumer Disputes Redressal Commission, District Commission, and State Commissioner Dispute Redressal Commission, State Commission, and National Consumer Dispute Redressal Commission, National Commission. It provides the alternative dispute resolution to mechanism exclusively for the consumer and the function as the quasi judicial bodies. Composition. President not less than the four or the not more than the such member of the member as may be prescribed. The central government 2002 prescribed the president and not less than the four or not more than the 11 member. At least the one member shall be a woman. The appointment. The president and the member appointed by the central government and the recommendation of a search cum selection committee chaired by the CGI and judge of the Supreme Court who is nominated by the CGI. Minimum age should be less than 50 years age. 10 tenure. The 4 year until they attain the age of the 70 upon 67 in the case case of president member whichever is earlier. Salary and allowance. The regulation of the president and member of the central government may make the rules provides for the qualification, appointment, salary, allowance, resignation, removal, and other conditions, services, and the president slash members. Power. The precautionary complaints who values the exceeded rupees 2 crore. The appellate jurisdiction, the interim appeals against the border of any state commission. The appeal may be made within 30 days from the date of the order of the state commission. It may also contain and the appeal filled filled after the expiry of the 30 days. It also has a jurisdiction to the certain interim the appeal against the orders of the Central Consumer Protection the Authority CCPA. The appeal may be made within the 30 days from the date of the receipt for the order from the CCPA. A revisional jurisdiction. The jurisdiction to the sale for the records and the passes appropriate order in the any consumer dispute that is pending before or has been decided by the state commission in the all following circumstances. The Central Consumer Protection Authority the regulate the consumer rights and violation of fair trade practices and misleading the disadvertisement and the harm the public consumer interest and the promote the enforce the consumer right. The central authority shall be consist of the chief commissioner and such member of the other commissioner as may be the prescribed to the appointed by the central government. The central authority will be the headquartered in the national capital regime of the Delhi and can be established regional other office and anywhere else in the India. Thank you for watching. Please watch properly. Thank you for watching.